Let's step back a moment and look at the two conflicting visions for America. The one given to us by our founding fathers, the other by the liberal courts that have taken their cues way too often from the American Civil Liberties Union.
Nowhere does the Constitution mention a separation of church and state. Instead, the First Amendment reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof.
The founders' intention of the First Amendment was not separation of church and state as we know it today, in the sense that you keep religion out of public life.
David Barton, author of Original Intent, has poured through hundreds of books, monographs, and writings of America's founding fathers.
On August the 15th, 1789, James Madison, on the floor of Congress in the middle of the debates, explained that the purpose of the First Amendment was to prevent the federal establishment of a single national denomination. That is their concept of separation of church and state. Don't let the federal government make us all one denomination. But that never was conceived to include exclusion of religious activities or principles from public life or public activities.
There's no more misunderstood concept in American law than the separation of church and state.
Frank Mannion is an attorney with the American Center for Law and Justice, which is dedicated to restoring full religious freedom in America.
We come from the matrix of the Bill of Rights, which is we don't want an established church. We don't want one denomination of Christianity, really. We do not want one denomination of Christianity made the government church over and above the others. And obviously the framers, if you look at it in the context, were thinking of the Church of England by law established. That is the statutory name of the Anglican Church. So the use of the term establishment was not just some word they pulled out of their hats. It was a specific reference to the Church of England by law established. So when we talk about not establishing a religion, that's what they meant.
The turning point in church-state matters was the 1947 Everson versus Board of Education decision, where the Supreme Court applied for the first time the wall of separation between church and state concept to the Establishment Clause. They got the words from an 1802 letter written by Thomas Jefferson to the Baptists of Danbury, Connecticut. This was ironic in light of the fact that Jefferson was in France when both the Constitution and the First Amendment were written.
In 1947, in the case Everson versus Board of Education, you had the situation where the court takes this phrase, a wall of separation between church and state, and decides that that has more significance in its wording than the Constitution does.
Another irony is that Jefferson's point in the letter was the so-called wall separating church and state was to protect the church from the state.
It's very clear that Jefferson's saying separation of church and state means that the government's not going to stop a public religious expression.
The Everson decision was written by Justice Hugo Black, who incidentally had almost been blocked from sitting on the High Court in the first place by the Senate because of his involvement with the Ku Klux Klan when he was in his late 30s. In his decision, Justice Black wrote, "The First Amendment has erected a wall between church and state. That wall must be kept high and impregnable. We could not approve the slightest breach." Court watcher and attorney Tom Jipping.
The First Amendment prohibits an establishment of religion. That is a fairly small category of things. It's a fairly narrow word, establishment. That's the word that's there. Judges have said, in fact, what that means is an endorsement of religion. It prohibits an endorsement of religion, a different word with a radically larger meaning.
Prior to the Everson decision, there were just a handful of Supreme Court cases dealing with religion. Since that decision, the courts have become clogged with all sorts of church-state cases, and the results we read about virtually every day. As one law professor puts it, the Establishment Clause has been converted into a search and destroy mission against any sneaky vestiges of religion left around.